Rich, you're muted.
I was just saying I was starting the recording.
Oh, gotcha. Thank you.
All right. So let's go ahead. There's enough people in here. All right. So this is a class on disclosures. As everybody knows, we have many disclosures that are required by the office and also required statutorily. So I am going to, let me share my screen. Let's see. All right. So I'm not sure which checklist you're seeing. Is it listing or buying? Somebody want to tell me?
Buying.
Buying. Okay, great. So every one of the offices has this checklist. It shows what is required by the office in order to complete your file. And you should check with your office administrator as to where to find a copy of this checklist. A lot of times it's on an e-drive, sometimes it's in my KW under documents. Every office does it differently, so I can't tell you on your office, sorry, there was a fly, where it is, but every office has this checklist for every type of transaction. This is a residential buying checklist, which includes now probate and manufactured homes, because you still use the RPA, the new RPA, for probate and manufactured homes, and you just add the addendum, whichever is appropriate, either the probate addendum or the manufactured mobile home addendum. But like I said, every office has this, and it lists all the disclosures that are required and all the documents that are required for a transaction. There are additional documents if they apply, but we're just going to go mainly through, I think we'll only have time for the normal disclosures on a transaction. So I'm going to stop sharing this and let me share the actual document. And you should be seeing the very first, when you're dealing with a client, the very first disclosure that you will have them sign. And that and it's usually bundled within whatever kind of transaction you're doing, either a listing or a purchase agreement. It's bundled with it. This is the AD, which is disclosure regarding real estate agency relationship, and this is required by statute. And all this document does is say what is a seller's agent, what are the duties of a seller's agent, what is the duties of the buyer's agent, and that there could be both a buyer and a this is full screen for me. I don't know. I'm looking at it, Alan, I'm looking at it from my screen and it shows full screen. Is anybody seeing it smaller than full screen? So anyways, let's go back there. Sorry. All right, so it's required by statute, and it also discloses that there can be dual agency where the agent represents both the buyer and the seller. Let's all remember that agency is in regards to the brokerage, not only the individual agent. Okay. Is anybody else seeing this not full screen? Because I'm seeing it as full screen. So let's.
Full screen, but it's tiny.
It's
It
full
has to do,
screen,
if
but
you
it's
guys check on the right side, sorry to interrupt you, Rich. If you check your view and you click
Yes.
standard instead of side-by-side speaker, it will be bigger because I'm looking at it and it's big.
Right. And also if you click on, if you click on that and I think it says, I don't know what it says, full screen. It may even say full screen. So it's on your end, Alan, so, and everybody else. So anyways, it's about the brokerage. It's not about the individual agent. So one agent in Calabasas and another agent in Calabasas who is representing one a buyer, one a seller, that's dual agency. So that is all this document, this disclosure is about. It's just informing the client of the different types of agency, and it's required by statute. The second page is the actual statute. That's all this is. So that is the very first document that you are going to present to your client, and it's really easy to explain in that all it is that it is talking about agency. So the next one I'm going to do, usually bundled with this, is okay, possible representation of more than one buyer and seller. So
But it's software company.
all right, somebody, let's all check, make sure we're all muted, because I can't see who's not muted. All right, possible representation of more than one buyer and seller. All this is saying is that we as a brokerage may represent other buyers looking for this particular property or similar properties, or we as a brokerage may be representing sellers of other properties similar to this property. That's all this is disclosing. So that's very easy to explain. The next one that you're going to see that is commonly attached is wire fraud. Once again, wire fraud, very important document, very important disclosure to disclose to both your buyer and to your seller. Doesn't only have to deal with buyers, it also deals with sellers. Make sure that you explain that never, ever will you ask or deliver to them wiring instructions, and to make sure that they verify those wiring instructions with escrow by picking up the phone. Weird concept. But picking up the phone and talking to the escrow officer or an assistant in the office. They should never count on wire instructions just via email. I've been involved in too many cases where money has been absconded with, large amounts of money, and it's not pretty, let me tell you that. Very important. And you should never be involved in wire transfer instructions. So just make sure that your clients, both buyer and seller, are aware of that. So that is that. Now, any questions on any of those? I don't really see any just now. Let me look at one thing. Hold on. Let's see where I want to go to next. All your faces are in my way. I can't see. There you go. All right. So Oh, and most likely this next one is going to change because I think there was a change in the law, and it is. Uh-oh. We have a problem here. Hold on. Oh, there we go. All right. The California Consumer Privacy Act and Advisory. I believe they just in this last vote not too long ago changed this law a little bit. They expanded it. So this form will probably change in June. But all this is saying to your client and every client that you represent, if you represent a buyer and a seller on a transaction, both of these need to sign this, is that, the MLS a lot of times gathers information about them, their email address, their phone, whatever, and what they do with it. It's out there that person's information is sold to several different parties. We are not a big enough brokerage that we individually, because it's per the brokerage, are a big enough in brokerage that we would be affected by this. But if we were a bigger broker, like the big brokerages, all of us have gone to a website where we use cookies, and you have to choose your what we're going to do with your information. If we were a big enough brokerage, then we would also have to do that, because we have to have instruction about what we do with their information, like gathering their email addresses and whatnot. So that's this disclosure, very important. Like I said, it will change. It will change in the coming months. Okay, let's go. Where do we go from here? Well, I might as well tackle this one when we're here. Okay. Oh no, let me go to this one. Everybody really should be using this form. I have it as mandatory, so you should have it in your file, but it's a great form, especially now in this changing market. Markets change, and this is just an advisory that of just that. The market is changing. Non-contingent offers. There's a great paragraph about non-contingent offers. And broker recommendations that, it's in here that not to write a non-contingent offer. Multiple offers, it talks about multiple sellers considerations. All of that is really important, and absolutely you should be using this and going over this form with your client, because especially in these conditions, we always say we don't have a crystal ball. Who would have thought that we would be up to six plus in interest rates? Never think that when we were down to 2 and 2.5 and all that. So very important document to go over with your clients. I realized I missed another one that is attached to everything you do, and let me go over that. Hold on. Fair housing and discrimination advisory, very, very important. Last month was Fair Housing month with CAR. They did a whole, I think on the 18th or something, they did a whole day of activities surrounding it. There are certain classes of people They are listed here in number 4 in California. Federally, the list is different, not as many, but these are all the Fair Housing Acts. It talks about we don't discriminate against any of these classes. Then would like to point out, where is it? It goes over what, improper conduct can be examples of improper conduct. Where is that? I thought it mentioned love letters in here, but it's on the actual listing agreement. I believe it mentions love letters. Love letters are those letters that buyers write that you need to go over with your seller, if you're representing the seller, and say, do you want to accept these letters? Because it can expose you to a fair housing complaint. I don't know how many times I've seen a letter, I'm a single mother, living alone, raising my family, blah, 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 blah. Well, if a seller makes a decision based on that person's marital status, protected class, and could get a seller into some trouble. That's why sellers should not rely on love letters, and especially you should not have pictures with your love letters. That's a big no-no, because it may influence. Alon, you had a question on this? Was it on fair housing? Go ahead and unmute, or write it in the chat if you want, whatever.
Can you hear me?
Now I can hear you, yeah.
Oh, wonderful. If you have, let's say, a buyer's agent call you and just volunteer information about their client, are you obligated to refer that over to the seller?
Depends on what your seller instructed you, because as a listing agent, you've had the conversation with your seller as to, are you accepting letters? Are you accepting this? If you've had the conversation with your seller already saying, we're not going to look at buyer's letters, then I wouldn't. That's buyer's letters are, I believe, are in quotes. I mean, it's also disclosing specific characteristics of the buyer. So I wouldn't. I wouldn't pass it along. It's like that's not something that the seller should be looking at in order to make their decision as to whether this is a good offer or not. The decision should be based on, can they close this transaction? Do they have the money to be put down, or are they pre-approved for a loan? Those are the things that they should be determining whether this is a good offer or not those types of characteristics. So I wouldn't pass along, no. So okay, moving on. Let's get to the nitty-gritty here, and then I'll go back and see what I missed. Okay, come on, where are you? There you go. TDS. This is required by statute that seller disclose information regarding a property upon transfer of the property. Those that are exempt are probate, are are surviving trustees of a trust, and bankruptcy or REO. So if somebody doesn't have knowledge of the property, then they're exempt in those categories, I should say. So every blank space is important, including the date. As I've said before, you should be checking no substitute disclosures, because the inspection reports pursuant to the contract of sale or receipt of deposit, it's a specific inspection report that deals specifically with the details of this document. And if you want to add additional inspection reports, do it in receipt of reports. Don't do it here. So no substitute disclosures. The seller is or is not occupying the property. Check that out. And then it's just checking, to the best of the seller's ability, what is present in that property. And roof type, roof age, approximate roof age, just have them say approximately how old the roof is, and whatnot. So it's to the best of their knowledge. Then as we go into, well, I'll go before I do that, this next one is significant defects or malfunctions in the following. So if they know of anything, they need to disclose it here. Now, if they've shared something with you and then you cannot fill this out for them. One thing, you can't fill this out for them. They have to fill it out on their own. So, but if they've disclosed to you information about something, like they had a leak somewhere, or they've whatever, if they've disclosed something and they don't disclose it here, you got to give them a little nudge. That's the thing. It's like, remember, you told me that it really needs the phrase here is disclose, disclose, disclose. We've heard it time and time again. Disclose, disclose, disclose. They need to disclose things. This is for their own protection, because if the buyer finds out about something that they didn't disclose, that's called a lawsuit, and we don't want to get into that. So encourage them to disclose it. If they still refuse to disclose it here and say, I have a responsibility to disclose it myself, and you disclose it on the app. It's just that simple. So it's better coming from you, Mr. Seller, Ms. Seller, but I will need to disclose it. So, and if they argue with you then I don't think it's the right client, unfortunately, because this can lead to, you can have, your license can be in jeopardy, you can be brought up on ethical charges, named in the lawsuit. I mean, so, because you have knowledge. So once you have knowledge, it has to be disclosed. And then here are the standard questions on the TDS, and it's phrased as, are you, seller, aware of any of the following? If you're not aware of it, then the answer is no. People they want to write in, I don't know, or unknown. It's just, are you aware? And if you look at all these questions as from a perspective of, are you aware, then it's clear that the answer is either a yes or a no. So, these are just standard questions. One of the major questions is it a meth house? I believe it is on here. about being a meth house. Also, room and additions, any alterations, they need to disclose that. And anywhere there's a yes, there needs to be an explanation, even if it's, are there CC&Rs and D? Have them put an explanation. Yes, there are CC&Rs or G. There are CC&Rs. So, or there is a common area. Pools in the common area. We have tennis court, whatever. If it's answered yes, then they need to have an explanation. Also on here is, has anybody died within the last 3 years? Also, we used to have the water heater and smoke detector disclosure. We no longer require that because it is handled right here in section D. Now, there are still some brokerages. Sorry. There are still some brokerages that still require that form. Excuse me. If they insist, then just have your client sign it and do it. Excuse me. Joan has a question: how to assist if English is not your primary language? How do you help your client? I would ask you, Joan, how do you help your client if English is not their primary language otherwise? I mean, you're saying, can we do the TDS with them? I would have somebody who's fluent in the language, reading over the form with them. That would be my suggestion. Sorry, I got a tickle. Then the next part is why is Christina's iPhone keep coming in? Who's the Christina's iPhone? Anyways, yeah, I've let in Christina's iPhone 5 times. All right, so the next section, the agent's inspection disclosure, is really, really important if you are the listing agent. If you are the listing agent, for one thing, the office, every one of our offices requires an AVID. This is required by law, by the way, that an agent do a visual inspection. Not that they fill out an AVID, but that they do a detailed visual inspection. It all stems from a lawsuit that happened long time ago. And because of it, it's been statutorily required that an agent do a visual inspection. CAR has put together this handy dandy form called the AVID, AVID, to help you do that. And for those of you who like Glide, which I am one of them, they made it even easier that you can do your, sorry, there's a fly around here that will not leave me alone. That Glide will help you do your AVID really easily. You can do it on your phone, you can take pictures, you can do all of that. So everybody's going to check that they're doing an AVID, whether you're a buyer's agent or a seller's agent, until you include that AVID. This TDS is not complete. So what does that mean? It means that if once the buyer sees your AVID, and even if they've removed all their contingencies, if they don't like something on your AVID, they can rescind the sale within 5 days. They can get out of it because this is statutorily required. The TDS is statutorily required, and the agent must do a visual inspection so that if they don't do this, then or they do it late, which a lot of agents, oh, I'll do it on the file and walkthrough, or I'll do it when the inspection comes. Even though this TDS is required to be sent to the buyer by default 7 days, but yet the agent waits till day 10, maybe 12, whatever it is. So until both of these forms are together, this is not complete. And even if the buyer has removed all contingencies and he doesn't like something on the Avid, of the listing agent's Avid, then he can cancel and get out of it. So it's very important that you do it. So,
Hey, Rich, can I ask
Yeah.
a question?
Sure.
So you mentioned the Glide Avid. I haven't used that, but I happen to get the escrow I'm in right now, the agent used that. But I
Mhm.
can't imagine that this is how it's supposed to be. So what he did was he attached photos, and in every comment, he wrote, see photo, see photo. He said nothing.
That's
in my
not
mind-
the right way.
Okay.
That's not the Glide Avid. I mean, it could have been done with Glide.
Yeah,
but,
he did it with Glide, and he made a comment when I was there, because he was doing it when I was there, and he said, "Wow, this is so easy." When I got it and looked at it, I go, "Wow, this is not okay." But-
Right. Yeah. I mean, when I say that the Glide Avid, the Glide thing is easy, is that it takes you room by room, and it's just the way that it's presented. It's easier to fill out, and the TDS and the SBQ can be sent to your seller through Glide, and it's like a survey. It's easier for the seller to fill out their disclosures because of the way it's presented. I would suggest you try it because it really is easy to work with. So and sellers like it a lot better than filling out this form, and you'll like it, even though it's owned by Compass. But anyways, we won't go there. So yeah. So that's not the way to do it. Take a picture and look at the picture, because the picture is only there as probably a backup to the words that you use. So yeah, no, I would not do it that way. So this is the TDS, which is required by statutes. And then there is required by contractually, because it's in the contract. Yes, Alon, you have a question on the TDS?
Yes, a quick question, at the very final section where it says that the agent is going to either check mark, see my Avid, there's another space for comments. What comments usually get inserted there?
Well, lazy agents. Nobody on this call is ever going to check anything except see my Avid, but lazy agents will check that mark for comments and say nothing noted, and they say they've done their inspection and there is nothing to report. There is absolutely nothing wrong with the property. So
I see.
Yeah.
Do we need to add anything, such verbiage as a buyer to conduct their own inspections and rely on their own investigation?
No, because
like that?
it's in plenty of disclosures that the buyer's advisory at the end of the offer, it's all over that. So you don't have to add that.
Got it. And if you, I see your cursor is right on the left side of the page. Can you go to the top left, and you see it says eSign, MLS Connect, Record Connect. Can you hit full screen, that fourth one? See what happens? Here you go. That's what I meant.
Yeah, but nobody sees. But did you go on view at the top of your screen And where are you in that?
No, it's just now it's bigger, so we can actually read the
No,
the
no,
text.
no. But I understand that. But
Yeah.
now it's like huge for everybody else, for one thing, and you don't see as
Oh.
much of the page. So
Okay.
so I would say on the where you are, where it says view, the very first option is where you should be in view.
Standard.
Standard, yes. And you should be able to see what everybody else is seeing, most of the document. So
Hey, Rich,
Okay.
I want to say
Yeah.
one more thing, going piggyback what Alon said, that section that he was talking about where those little boxes. So I've seen lots of times the agent will write, type in avid to follow. I mean, I
That's-
guess what you're saying is it doesn't really matter because like you said, they get the timeout if they need it, if it's not there.
right.
Okay,
Right. I mean, avid to follow, yeah, fine if you want to say avid to follow, but know that if you're the listing agent, this document that you're signing is not complete until that avid to follow is received. So just because you put avid to follow doesn't really matter. So the SBQ is required contractually, which means it can be written out of a contract. So but I wouldn't have any of you do that, but just, if somebody if you get something, it says SBQ is seller not to supply SBQ, they can do that because it's not required statutorily, it's required contractually. So I would counter it back in if you're representing a buyer, because what is the SBQ? The SBQ is the TDS on steroids. It goes deeper into everything that that is being asked. So once again, there's the contractual, statutory or contractually required in the 3 year, does somebody die in the 3 years, and all of that. Talks about specific, dials down a little more about repairs and alterations, structural and appliances. This was a new one. They added disaster relief insurance or civil settlements, water related or mold issues, pets and animals. Yes, there are pets. It's like, well, what are, like I said, a lot of people think, well, just saying that there is a pet is enough. I would write what type of pet, because frankly, if somebody had snakes, I wouldn't buy that house, because I'd be afraid that one of them got away and they're crawling around in that house. So so I would want to know what kind of pets somebody had. Boundaries and access and all of that, landscaping, condominiums, title, liens and legal claims, neighbors and neighborhood. This is very important. Those neighbors, those pesky neighbors, somebody having a specific problem with a neighbor. It used to just be neighborhoods, but they added neighbors to it. So it's very important, because somebody told me a situation where the person was selling their house because the neighbor across the street was shining brightest light onto their house, just because I don't know, they didn't like each other, and so that needs to be disclosed. Alon, you had another question?
Yeah, I had a question regarding the first page regarding death on the property. I know that you have to disclose within 3 years there was a death on the property with the exclusion of AIDS.
Right.
What about if you had a death on the property, say 5 years out, but the buyer asked you if there was death on the premise? Do you have to disclose that?
If you have knowledge of it, I would disclose it. Absolutely. If 20 years ago there was a notorious murder on the property, I would definitely disclose that. I mean, because talk about neighbors, Gladys Kravitz is going to come by and say, "Oh, you bought the murder house." You know it's going to happen. So yes, you should be disclosing that. So yeah. Governmental, then other, any occupant of the property smoking or vaping any substance. That's funny. I never really looked at that before, but anyways. And once again, these questions are you aware of these things? So if they're not aware of it, then the answer is no. So that is the SBQ. Any questions on the SBQ before moving on? So I'm going to go over my favorite form, especially for your listing agents. It's my favorite form. Why? Because this is the first. If there is a dispute that something wasn't disclosed, this is the first thing that an attorney is going to look at. And it's the most important form you are ever going to fill out in your career. And you should think of it as such, because it could get you into a lot of trouble. So stress that you need to take your time when doing your audit. It's not something that you can rush through, because another thing they're going to look at, and when they look at it, and because they're going to ask you in a deposition, how long did it take you to fill this out? And you're going to say, oh, I took like 45 minutes to an hour to fill it out, or however much time you say it took you. And you have written on these, oh, nothing noted, nothing, and it's going to say it took you that amount of time to fill this out. So take the time to fill it out. Notate everything you see. That's what it is. It's a VAVID. It's a visual inspection, and no matter how minor it is, a scuff on the wall. And once again, this is to discourage. The point of this document is to discourage buyer from buying it, because they are made aware visually of everything that is wrong with the property. That's the real point of this document. It's not a marketing piece. It's not a piece to say there is marble countertops or hardwood floors. No, it's a chip in the countertop. It's a scratch in the floors. It's every little thing that you see, you go through, and you notate as to what you see as a problem. But we don't assess what the source of the problem is, because if there's a stain on the ceiling, you don't say it's a water leak. You don't know it's a water leak. You just say it's a stain. You say, and you don't say big stain. Don't use adjectives. Just matter of fact, what you're seeing. I'm seeing a scuff on the wall. I'm seeing a chip on the floor. I'm seeing, whatever it is, just matter of fact of what you're seeing. And even though it's a visual inspection, it also, you should take into account what you smell, what you hear. So if there's a lot of street noise, you're going to say there's street noise is heard. Or right now I'm hearing a helicopter. I just had my patio doors replaced with double pane. I shouldn't be hearing that. Anyways, but I'm hearing a helicopter over my head. So if that happens while you're doing an Avid, you notate that. If there is a certain smell, you can't identify the smell. Just say there is an odor in whatever room that you smell an odor. I mean, just point everything out. And you go through room by room, and this is what's easy about Glide is that it's really easy to go room by room, and if you go over too much text, it automatically generates an overflow addendum. So it's really good in that respect. What is everybody asked me, what is other for? It could be other rooms. It could be other things that you know about the property. If this is where if or either at the end, other observed or known conditions that you would put if the seller has disclosed to you, some specific thing about the property they don't want to disclose. You can disclose it here. If you know that the heater was serviced, in the last week or so or whatever, you can disclose stuff like that. The exterior also, you need to go around and look at, are there sidewalks that are uprooted? Could be a trip hazard. Is there stucco missing? Is there holes in the stucco? Is the roof, a shingle falling off the roof? I mean, these are all things that you would notate. Somebody asked, what's the example of weather conditions? Well, it's raining. It's a sunny day. Those are all, they want you to notate that. Because if it's a rainy day and you notate that it was a rainy day on this day and you didn't observe any leaks, then that's relevant. But if it's a rainy day and you're observing leaks, then that's relevant also. So does the listing agent have to do this disclosure? No. Somebody in the brokerage does have to do it. And if you have an assistant, they can do it. But you need to make sure that you trust that person to do a thorough job, because they're doing it on behalf of you, especially listing agents. So it's very important that you trust the person who's doing it. During COVID, and I get a lot of, well, I'm away. I'm out of town. I took this listing 100 miles away. I took a listing in Palm Springs. I have to go. I have to do an Avid. Yes, you have to do an Avid. I'm not going to say you have to drive to Palm Springs to do the Avid. You can have, if your seller is still living in the house, you can have the seller walking around, while you're on FaceTime or Zoom or whatever it is, and you can do. And as long as you notate here in this, where would I notate it? I guess I would probably add an addendum and call it an addendum to the SPQ and say that the Avid was done by such and such agent via FaceTime or Zoom or whatever. Disclose, this is how I did my Avid and this is what I saw. So that a lot of that happened during COVID. So so that's the, any questions on the Avid, because it really is an important document. Nope. Okay. I am not going to go over the fire hardening because, and why I'm not going to do it is most likely next month it's going to change. either next month or on in July. They're either going to do a special release in July because it's things are changing a little with it, because they're taking into account not only the state maps, also county and local area, because every map is different. Your NHD company is well aware of this, and they've been making adjustments in anticipation of that. Let me see. Here we go. Let me see what other. Oh, I know what I wanted to cover. There is one disclosure that I want you. It is mandatory for all my offices. When you're taking a listing, the disclosure information advisory, you should be giving this to your seller. Why? Because it explains to them how to do these disclosures. Preparing to complete your disclosure obligations, how do, instructions for completing all disclosure forms. It saves a lot of work. So you should be, and it explains the TDS, specific things about the TDS, the SBQ, if they're an exempt seller, it goes through that. It's an invaluable document for if you're working with sellers. So if you hadn't heard about this, then you should be doing it. Absolutely, you should be doing it now. Let me look at one other thing, see if there's any other things. Okay. So if a property, where am I? No, that's the wrong one. If a property is built before 1978, that's 1978, you have to do a lead-based paint and hazardous addendum. They've changed this a little, that they want the the default is the seller has no knowledge, but if they can add things if they've done any reports. They've kind of simplified it a little more and made it easier. So 78 and before, you are required to do a lead-based paint. The other form that is required, come on. Okay. Oh my God. No, wrong one. Water conserving plumbing fixtures and carbon monoxide detector. So this goes over, water conserving, fixtures, and it talks about, it takes the place of the water heater braces, the water heater and the smoke detector thing. We used to have to do that one plus a carbon monoxide form. This takes care of everything, and just make sure that all parties sign it. What happens if somebody doesn't want to sign it? At the very least, for one thing, these are, besides the TDS, which is required statutorily, and the SBQ contractually, all these other documents are just disclosures. They're just information. I don't know why so many people get bent out of shape about signing something. What am I signing? Blah, blah, blah. You know, but it's just information. So at the very least, your own client should be signing it. Just make sure that that your client is signing it. If the other person's client doesn't want to sign it, get something in writing from the other agent saying that they refuse to sign it. You know, I mean, so many people get really nasty about it. It's not required. It's well, my office does require it. Will your client sign it? No, they won't. Please send me that in an email. Attach it to the form that your client has signed. Attach the email that says that the other party is not going to sign it, and you're done. You don't have to scramble around, try 3 times, all of that. If they're not going to sign it, then you can't force somebody to sign something. The only thing that's really, really important is the TDS and the SPQ that they should be signing or they should be filling out. And if a buyer doesn't want to sign the SPQ or the TDS saying, I'll show him, I'm not going to sign it, it doesn't matter. It's been delivered. Your signature is only an acknowledgement that you've received it. But guess what? We have an email trail that shows that you received it. So you're not pulling something over on somebody just because you're not going to sign that. So the last thing that I'm going to go over really quick is the earthquake report and that thing, the receipt and all that. So you're seeing this forms. Confirm to me that you're seeing forms library here in the right hand side. Somebody, you're seeing this, right? Where my cursor is?
Yes, yes.
Okay, great. So for these forms, you need to pull down that forms library. You'll see all of these different associations because I belong to all of these ridiculous associations. So each one of them has their own forms. And so their library is in mine. But you'll go down to California EPUBs. I have no idea why this stuff is here, but that's where it is. So you go to EPUBs. The actual guides are right here that you can email to your client. So it's the residential environmental hazard, it's the lead, it's all of this is right here. So, and then 5 of 6 is this form. Stop doing that. I'm pressing too hard, sorry. 5 of 6 is this form, the residential earthquake risk disclosure statement. And this is required on a property that is built 1960 or earlier. So if it's 1961 on, you don't need this form. But if it's earlier than 1960, you need this form. And they've made it easy for the seller. They've given you the option of doesn't apply, and I don't know. So does the seller know if their water heaters braced? They've checked. I don't know. So just have the seller sign this and fill it out and sign it, and that's done. So then you excuse me. And then number 6 is the receipt of the guide. So all those guides that you emailed from EPUBs to your client, they can sign and say, yes, I did receive them. So that's it. So let's see what Alon has a question about TCs. Go ahead.
Yes, I have a question. I know it's a wonderful tool to use. But ultimately, who's responsible for any potential errors done by a TC? Is it the agent?
Yes. That TC is your employee. They're your representative. I just love it when an agent says, "Oh, that's, I just, give that to my TC, and they're supposed to do it." And that's why those previous reports were never sent to the new buyer, and that's why we're involved in a multi-million-dollar lawsuit. It's like, I'm sorry, but that TC works for you, and ultimately you are responsible to get those reports. If you know those reports exist, you're responsible for that. So and who are they going to go after? Are they going to go after the agent who got a commission off of this, or are they going to go after somebody who's paid $400 and they're an employee of that? It's ultimately it's your prerogative to hire somebody to do your paperwork, because God knows I know that agents hate to do paperwork. Now, I was an agent who loved to do paperwork, and I actually TC'd for other agents, and I loved everything about the paperwork, but I'm the rarity. And
I'm with you, Rich. I do all my own TC because
Yeah.
I love it. It's one of my favorite parts.
Exactly.
And
So,
I caution what Alon was saying. I've had to clean up after TCs that I use, and I
Yes.
decided it's absolutely not worth it for me.
right.
I mean, if I have 10 deals going on, okay, but no.
So,
Yeah, so thanks for clarifying, because a lot of agents are under the impression that, hey, I'm hiring somebody to do this job, therefore it's no longer my responsibility,
No.
and in turn, it's not accurate.
no, it's not. That isn't accurate. And be careful of. I noticed for a while there that of TCs who were writing up clauses for a contract, who thought they knew everything about a transaction, and who knew more than the agents knew. And they may know more than the agents know, but a TC, the job of a TC is to distribute and collect paperwork. That's it. You shouldn't be hearing from a TC about anything else. I mean, I love TCs. I've met a lot of great TCs, but the minute you as a TC are trying to tell the other agent how to do their job, that's not their job. That's not their job. And I would strongly caution the employer of that TC, saying this is not their job. I've had many arguments with TCs saying, whoa, you are not a lawyer. You cannot be doing this. You have to back off and just, do what you're hired to do.
It's very true, because I've dealt with TC that work for mega agents, and those agents really were clueless as to the paperwork. They're 100% dependent on their TC, and if their TC were to make a mistake, they'll be on the hook.
Right, exactly. Absolutely, they're on the hook. Yep.
All right,
So
thanks.
that's it. Anybody else have any other questions? I don't see any. Bueller. Okay. Well, thank you for, I'm going to stop sharing. Thank you for joining, and let me stop recording.